Hi everyone, my name is Lena Nguyen. I'm a family law attorney. Today I'm going to talk about the different ways you can handle your divorce without going to trial. Taking a divorce all the way to trial is a lengthy and expensive process. However, a trial is not always necessary to resolve your disputes or your divorce. There are alternative dispute resolution methods, also known as ADR methods, that will assist parties to come to an agreement without litigation. These out-of-court proceedings are designed to facilitate settlement. The first method is negotiation. It's basically talking to one another. This is the least expensive method of dispute resolution. It's a process that allows the parties to discuss the issues rationally with each other and come to an amicable agreement on their own. They get to decide for themselves all the important issues concerning the divorce. Parties who negotiate have full control of the divorce process. If lawyers are hired, the lawyers will be in charge of drafting a decree that reflects the parties' agreement. The most difficult part of negotiation, though, is actually getting both parties to agree to negotiate and cooperate together. The second method is mediation. Mediation is a structured process where both parties agree on and hire a neutral third party. They're also known as a mediator. They'll assist the parties in reaching a solution. During mediation, the parties are usually kept in separate rooms with their respective attorneys if they have one, and a mediator hops between the two rooms to help facilitate an agreement. In divorce and family law cases, a mediator with extensive knowledge of family law is usually hired. The third method of resolving a divorce can be done through arbitration. Arbitration is a resolution technique where an arbitrator who is chosen by agreement of both parties is used to settle the dispute. An arbitrator is basically a private judge hired by the parties, and the entire process is treated like a mini trial. The arbitrator will review testimony and evidence prior to making a final decision, which will be binding on both parties. The fourth method, and a relatively new method, is collaborative law. Collaborative law is where both parties hire separate attorneys whose job it is to help the parties come to an agreement. The parties begin this process by signing a contractual agreement which sets forth terms of the process. Some of the terms of the contract may include treating each other with respect, voluntarily disclosing all documents that are necessary to reach the solution, and agreeing to share any experts if hired. The most important aspect of this method is neither party may go to court. If the parties do decide to go to court, the attorneys must withdraw from the case and the case will begin anew.
Thank you so much for watching. Please give this video a thumbs up and subscribe to my channel. Also, if you live in Texas and would like a free self-help divorce kit, please check the description box below to sign up.